All right, thank you very much. The next guest speaker is going to lead on from PI to when you're not very well prepared and you want to think about your next steps. This is Tim Nesbitt QC from Outer Temple Chambers.
Good morning, everyone. As Carolyn said, I'm here to speak to you about the subject of appeals. How many of you in the room have actually run appeals to what is the upper tribunal, was once the Transport Tribunal? Well, very few of them, but very few of you. But it's really, this is about what to do if it all goes wrong and you get the worst case scenario of a revocation or a sanction that your client can't live with, imposed on you at the hands of Mr. Turfitt or one of his colleagues. It's the cry of the layperson and the inexperienced that surely I can appeal and British justice will set things right for me. Well, as I'll seek to explain in this brief talk, the truth is, although there is a right of appeal, there is often some hope, it is very far from easy.
Down button.
Down button, thank you. However, a precursor to a right of appeal, there is a limited right to request the Traffic Commissioner to review his or her decision. Occasionally, you can ask for that if there has been what the legislation calls a breach of a procedural requirement. I think in my career I've only succeeded in such an application for a review twice. It's very limited. It's usually limited to circumstances in which there's been some sort of failure of a notice provision, but it is worth asking the question, has there been a fundamental breach of procedure which allows you to ask the Traffic Commissioner to think again? However, if that, in the likely circumstance that isn't the position, I now turn to rights of appeal. First of all, where the rights are derived from, well, you're probably all aware of this. The Acts of Parliament which respectively create the regulatory regimes for goods vehicles and public passenger vehicles, the Goods Vehicle Licensing of Operators Act 95, the Public Passenger Vehicles Act 81, each have express statutory provisions which create a right of appeal to the upper tribunal. So that is a right granted to goods vehicle operators and to public passenger vehicle operators. In addition, since 2011, transport managers have a right to appeal against decisions taken against their personal repute and what was, for a while, decisions that were taken against professional competence. There's less scope for those decisions now, but transport managers are now given a right to appeal by some regulations introduced in 2011. What you can appeal, the legislation defines just by virtue of the way it defines the right to appeal, the type of decision you can appeal, and it's really limited to substantive decisions at the end of public inquiries. So usually sanctions, most typically revocations, disqualifications. What you can't appeal is interim decisions. So you can't appeal a refusal for an interim licence. You can't appeal an interim decision on a procedural issue such as the admission of evidence. You have to wait until the end of the entire process. The upper tribunal itself appeals, as you'll know, used to be to a body called the Transport Tribunal. That was a dedicated transport appeals court, dedicated to transport appeals from the traffic commissioners, and it had a core in the early 2000s of 4 judges who were experienced in issues of transport law and had a deep-seated understanding and knowledge of the regime, and they sat with 2 lay people who were drawn from the transport industry. Although it was a tough appellate forum, there was a real sense appearing before that forum that they understood it and they knew what they were doing. Since 2007, however, the Transport Tribunal became the upper tribunal. This was a civil service Ministry of Justice-led initiative to fuse a large number of previously existing appellate forums into one body, the Upper Tribunal, created by the Tribunal Courts and Enforcements Act of 2007. As always with these things, it was designed to save money and to streamline. The consequence is that appeals and traffic commissioners now are to the upper tier of that upper tribunal, a chamber called the Administrative Chamber. That is the senior of the chambers in the upper tribunal. So at least the authorities have seen the importance of the work we all do by making the appellate structure go to the most senior level of judge. However, although initial appointments to the judicial positions on transport cases were drawn from the people who'd sat in the Transport Tribunal, in recent years, increasingly, the appointments are drawn from a pool of judges who are not transport specialists, who have expertise in things like social security law, parts of property law that are also dealt with in the upper tribunal, and really don't have the knowledge of transport law that the judges used to have. And it's made appeals more unpredictable than they used to be, and frankly often, depending on the judge, you get more difficult. Some are just not really very interested. And it has also made it more difficult to predict how you need to present the appeal, because you can no longer assume that the judge is steeped in the principles of transport law that transport lawyers and yourselves to a degree are no doubt familiar with. So it has made the running of an appeal a more unpredictable exercise. The next slide. Sorry, I may have gone too far. No, the grounds of appeal. I wanted to talk to you about Have you all received a handout? You've got a paper handout. I'm not quite sure that the slides you're seeing are matching it. So, if that's not the position, I'm sorry. In terms of how to appeal, if you look at the third of the pages of that document, and I think this is the point at which the slides may not match what's on the screen. The time for appealing, of course, that's crucial. You've got 1 month from the date of the decision letter. The notice is required to be filed by 5 p.m. on the last day, so the month that mirrors a month after the date you receive the decision letter by 5 p.m. on that day. How to appeal, the next slide down on the paper handout, as I note there, you don't need permission to appeal. So again, this is a concession granted to the industry by Parliament. For most appeals to the upper tribunal, you do need permission. That's to say you need to ask the judge below, the traffic commissioner, if it's a person equivalent to the traffic commissioner, or the tribunal itself, for permission to run an appeal. And that's a screening exercise that will result in a lot of appeals going nowhere. In the transport sector, you don't need that permission. The form for notice of appeal, I've given you it's in quite small print, I'm afraid, but I've given you the link, the government link to that form, and also to some government guidance on the appeal process. And then the next slide down, I've given you the address that you need to send the appeal documentation to, as well as giving you the phone number of the member of staff at the upper tribunal who deals with transport appeals. I think she'll be thrilled that I'm giving you her phone number, but it's worth, if you do put in an appeal for a client, it is worth checking that the document has been received, because you can have terrible problems if it hasn't. I next want to address you on filling out the notice. There are a number of key sections in that notice that I've given you a link to. Summary of the type of case. You will want to just, in a few short sentences, explain that it's a decision from appeal from a decision of a traffic commissioner, explain what that decision is and the legislation the appeal is brought under. The most critical part of filling out the form is the grounds of appeal, which is section F of that form. And this is a really important part of any appeal process. You need to get it right. You need to avoid generalised grounds of appeal. The upper tribunal have been very, very critical on numerous occasions of appeals that are attempted to be run with advocates who've just drafted generic grounds of appeal of the sort they see in case after case. You need to be focused and specific to your particular case, and you really need to be sure to run points that you think have real merit. It damages any appeal for you simply to chuck as much in as you can think of, because then you've got an appellate tribunal facing arguments that at the end of the day are not going to win, and they won't trust you on your good points. So really try and filter out and run with only the good points. But nonetheless, the tribunal also says, conversely, you do need to set things out fairly fully in your grounds of appeal. And I do actually recommend it. You'll say I would say this, but if you are putting in a notice of appeal, it is worth getting professional legal assistance for the drafting of the grounds of appeal. The question of parties to appeal, which I address in this slide, unusually in an appellate process, you usually appear before the tribunal without an opponent. Traffic commissioners aren't represented at appeals. The Department of Transport sometimes appears as an interested party, and the upper tribunal has been keen over the years to encourage the Department of Transport to instruct lawyers just to assist the tribunal. The Department of Transport displays an unwillingness to spend money on that, and it's only in cases where they consider that there's a real general public interest that they will do so. The impact on the arguments, the way in which an appeal goes of that, is that one often finds that the appellate tribunal is framing itself almost as your adversary. So you have quite powerful triple adversaries throwing questions at you if you're running an appeal, rather than in other settings where there are respondents to appeals. The appellate court will tend to be less intrusive. The question of stays I wanted to address, which is only on the written the written handout, and this is obviously a critical question if you do find yourself in the worst case scenario. Appeals are often pointless if you can't get a stay, because your client will go out of business. It used to be the position that in most cases one was able to get a stay. That is definitely not the position now. The climate has changed. You must first ask the traffic commissioner for a stay. That needs a carefully crafted and delicate approach to the traffic commissioner, because you are telling the traffic commissioner that he or she got the decision wrong, and they don't like that. They're uncomfortable with it. You put their backs up. So it's important to craft your letter to the traffic commissioner delicately and sensitively. And if refused, you have a right to renew the request to the upper tribunal, at which point you can perhaps be less delicate. And indeed, I'd encourage you to be so, because the principles which are the leading case on this is a case called Ptarmigan Solutions. The upper tribunal in that case identified the most important issue for any request for a stay is the merits of the appeal. So at least on a request for a stay before the upper tribunal, you need to go in hard on the merits of the appeal, why the traffic commissioner got it wrong. And without convincing the upper tribunal that you've at least got arguable merits, it's going to be very difficult to get a stay. The other factors that are important to the tribunal on the case law are the fact that, as you'll all appreciate, if you don't get a stay, it's often putting a business out of business. And the tribunal recognises that, but you need to make it absolutely clear and explain why that is the consequence. And the tribunal recognises that in those circumstances, if a stay is not granted, if an appeal is subsequently successful, it may well be that there is completely irremediable damage that is done to the business, and that is a grotesque injustice. And you need to make that point. The other feature to address is road safety and the protection of fair competition, two of the critical things that the whole regulatory regime is designed to protect. Often revocations are because of road safety concerns. If you're applying for a stay, you need real effort in addressing how those concerns will be met in the interim, because the tribunal, the nightmare scenario for commissioners and tribunals is that if a stay is granted and in the meantime there's some catastrophic accident that is down to failure in procedures by the operator, it's horrific for the regulators. As I say, this is an increasingly difficult climate in which to get stays, so you can't assume that just because you're appealing you'll get one. I want to just address you on the nature of appeals. A paragraph, an amended paragraph in Schedule 4 to the Transport Act 1985 sets out the nature of the appeals in theory, and it says that the upper tribunal is to have full jurisdiction to hear and determine all matters, whether of law or fact, for the purpose of exercise of any of their functions under an enactment relating to transport. And that means, although quite commonly it's said that you only have an appeal on a point of law, in fact the tribunal is fully seized of all issues of fact, of law and fact. It's complicated what that means in fact, in practice, about what you need to do to succeed in an appeal. And it goes on to say that paragraph that the upper tribunal may make any order that it thinks fit or remit the matter to a traffic commissioner. So the upper tribunal is fully seized of the power to do whatever it wants. At least it can do as much as the traffic commissioner could have done. However, the case law that is built upon that legislative framework is quite restrictive of what you need to do in order to succeed. It's a very high threshold. It's not what lawyers call a rehearing, it's a review. So you can't just argue the case again. You have to show that the decision is wrong. And what the tribunal regularly trots out a passage in a decision called Bradley Fold, which builds on case law in the law at large, in which they say this: it's not enough that the tribunal itself might prefer a different view. The appellant must show that the process of reasoning and the application of the relevant law require the tribunal to adopt a different view. And this is commonly referred to as being a requirement to show that the traffic commissioner was plainly wrong. And that is a high threshold. I just want to, yes. One issue that, however, the upper tribunal, this is quite a subtle issue I'm going to talk to you about, is fully seized of, is proportionality. And this follows on from the passing of the Human Rights Act in the early 2000s. The one consequence of that legislation was that the possession of a licence came to be recognised as a piece of property that was protected by a provision of the European Convention on Human Rights called Article 1 of the First Protocol, which protects the right to property. And the right to property can only be interfered with by an organ of the state, and a traffic commissioner and the Transport Tribunal, Upper Tribunal now, are both organs of the state, if the interference is proportionate. And that's where proportionality came to be fed into the whole of the regulatory framework, really. And one consequence of that is not only that the traffic commissioner is obliged to consider proportionality when considering whether to revoke a licence, but because the upper tribunal is also an organ of the state, it itself has to keep an eye on proportionality. And in a case called Brian Haulage number 2, the tribunal said that, and you may know this is the key test for traffic commissioners, but it also raises its head in appeals. The question is not whether the conduct is so serious as to amount to a loss of repute, but whether it is so serious as to require revocation. Put simply, the question becomes, is the conduct such that the operator ought to be put out of business? On appeal, and this is the critical point for appeals, the tribunal must consider not only the detail of cases, but also the overall result. And that gives rise to one of the arguments, as I'll explain, that is often run on appeals. Common arguments that are run on appeals, well, yes, the first one is a failure to apply the legal test of proportionality that I've just set out, and there it is again. Really, traffic commissioners in their decisions, and they usually do, but they're obliged to really set out a version of this question. And if they don't, they will usually be found by the tribunal to have erred in law. So that's usually, any time I'm asked to advise, that's really the very first question I look at in the decision. Have they got that test right? Another test, which they're usually in most circumstances expected to ask to apply, has become known as the priority freight question. That is the question, the question that arises in that case is simply, how likely is it that the operator will in future operate in compliance with the operator licensing regime? And that echoes the point that Carolyn made about this being a forward-looking regime. If you've got your ducks in a row at the date of the inquiry, it is much more difficult for that question to be answered negatively, much easier for it to be answered positively. And if the case law says, if the answer to that question is that it looks likely that they will in future be compliant, then almost as night follows day, the licence is retained. And usually the tribunal will expect a version of that question to have been posed. The next common ground of argument on appeal that succeeds relates to the quality of reasoning in decisions. There are various conflicting judgments over the years about what's required of traffic commissioners in relation to that. I think the high point of what the tribunal expected of traffic commissioners was probably 10 to 15 years ago, in the days of when I think Philip Brown was the senior traffic commissioner particularly. There were quite often the tribunal was quite intrusive, quite interventionist in finding that there was inadequate reasoning in decisions. They've rode back from that somewhat in recent years, as they have in many areas, but in a case called Severn Valley Transport, the principle is summarised: decisions should contain sufficient detail to allow a person with experience of the haulage industry to understand the basis upon which the decision was arrived at. Well, you may think that's a fairly minimal requirement, but it is always worth looking at whether the commissioner has really explained his or her rationale for the decision in a way which is coherent and understandable. And in a case called Yorkshire Rider, they said this: we have to say that the traffic commissioner does not give any analysis of his reasoning at all. He sets out what has occurred at the public inquiry and says that he's taken everything into account, but he then goes directly into his conclusions, and they then pose a series of questions that he didn't address before finding that the reasoning was inadequate. Another common argument run on appeals is one related to what is called the balancing exercise. That's a requirement on traffic commissioners that they need to weigh in the balance the positive features of an operator's case and the negative features. And again, that's an area where the expectations of the tribunal some years ago were much greater than they are now. They were, I think in about 2004, there was a decision called Brian Haulage number 1. It's still worth referring to. A decision of Her Honour Judge Beach in the early days of her judicial career. She's rode back from her generosity to operators that decision displayed. But there is still an expectation that the certain minimal requirements of a balancing exercise, and in a case in 2010 called S.A. Taylor and M. Taylor, they said this: there are three main ingredients in a properly conducted balancing exercise. First, the identification of all the relevant factors. Second, an assessment of each. And third, the conclusion, which must explain why one factor or group of factors outweighs another or others, and so provide justification for the conclusion reached. So that's another issue to look out for, the presence of a proper balancing exercise on considering an appeal. Very often, those are some of the other categories here. I've expanded upon them a little in the written handout, but the question of bias is one I'd particularly focus on for a moment. This is often what clients want you to argue. They think the Traffic Commissioner has been prejudiced against them. It's difficult to run a bias argument, but slightly surprisingly, it's not as difficult as you might think. There have been, I think, half a dozen occasions in the last 12 years or so when the tribunal has been prepared to say that the Traffic Commissioner's conduct displayed bias. Bias in this context is an objective question derived from a decision in other contexts of the predecessor to the Supreme Court, the House of Lords, in which the court said this, that the question is what the fair-minded and informed observer would have thought, and whether his conclusion would have been that there was a real possibility of bias. And sometimes in cases where Traffic Commissioners have behaved, have been overly aggressive or have said things which seem to demonstrate a prejudgment of an issue, one has been able to run a case of bias. But it's difficult. You need to have real care in doing so, and you're going to put backs up. And the tribunal, in a case called EA Scaffolding, spelled out a special procedure that needs to be followed in any case in which an allegation, an appeal, is to be run on the basis of bias. That decision you need to look at, but you need to set out the basis on which a bias is alleged in an affidavit, and responses will then be invited from the Traffic Commissioner and possibly any other witness involved. Other principles that one needs to look out for are breaches of rules of natural justice. That's quite a technical subject, but if you have the feeling that your client didn't get a fair hearing for some reason, that can often be instinctive, but it's worth looking at that, perhaps consulting a lawyer as to whether there's a real technical ground which can be identified on which such an argument can be run. There's the question of substantive proportionality. Does the decision just feel too harsh? And then failures to have regard to, so an omission to mention evidence which seems to you to have been relevant and important. That can found an appeal. And finally, disqualifications. In some ways, well, often disqualifications are a more realistic target for an appeal than a revocation. Quite often the case that the appellate tribunal will refuse an appeal against a revocation but allow an appeal against a disqualification, reducing perhaps the period of disqualification or scrapping it altogether. And that can be of really critical importance for an operator, because once that has gone, you have a green light to make a new application. So that is really critical and really worth thinking about. It feels a bit like a consolation prize, but it can have real value if you can appeal a disqualification. I finish with some statistics which I counted these up myself, so they may not be absolute gospel, but I think their ballpark figures are right. This year, so we're in October, 37 appeals, 10 have been successful. 2018, 26 appeals, 6 were successful. 2017, 31 appeals, 13 successful. 2016, 34 appeals, 6 successful. 2015, 70 appeals, 7 successful. So the appellate advocates are doing a bit better in 2019, but the overall percentage over 5 years is about a 21% success rate. So as I say, it's not easy, but it's not impossible. So if you do find yourselves in a situation where you or your clients are facing a decision which you really can't live with, revocation, something that's really going to threaten a business, it is worth looking at the question of an appeal, and you should always consult Carolyn.
Beating up on you. Wait a minute, has anyone got any questions for Tim? Alan?
You mentioned that the judges of the upper tribunal
There are none of them here, are there?
are no longer
Right.
transport biased.
Right.
Are the 2 lay members drawn from the transport?
They are still, yeah, they are, yeah.
Any other questions? I think you got off easily there.